Madam Clerk, will you call the roll, please, for the
Alderman-
Public Employees Committee?
Alderman Williamson,
Here.
Alderman Cone, Alderman Ornowitz,
Here.
Alderman Kotar,
Here.
Alderwoman Green, Chairman Tyus,
Present. Green is excused. Cohen, I'm gonna excuse him, but he's supposed to be getting off, so,
okay.
okay.
Alderman Cone, Alderman Green, 4, President have a quorum.
Thank you, gentlemen, for being here. You saw what these, the subject is, we don't get much assigned to us, but, since I've become the Public, Employees Chair, I have received all kind of feedback from different employees about things that are going on in the city. And I realized that I don't know enough about what's going on or how people properly complain. I know that, Alderman Williamson, I think you sponsored a whistleblowers, bill a few years ago. But I don't know that our employees know how to address these issues. You know, even though we have things, we don't do, you cannot steal them yet. Just a minute. You cannot, they don't know how to address the things still, and they don't know who to talk to. So I get all these anonymous letters. I mean, I got a stack of them, just from them knowing my name over the years. So I thought that we should have something that's everybody knows about on this committee, and then something that we could put out to the employees better about how, if they're being harassed sexually, if they're being intimidated racially, if they're being passed over for employment, black, white, green, orange, whatever, if they're being assaulted. And then I found that we have a loophole in our whole thing as far as when people go work for accepted offices, that we really didn't have a way to address that issue. And I found that out personally, because this was done personally to me. And so I'm very fortunate to be able to work with personnel. Got very smart people over there. So I have Mr. Richard Franks here and Miss Sylvia Donaldson. If you two would sit at the end of the table, they brought us some handouts, and we're gonna learn about how to complain effectively in all branches of government. And I know that several people have to go over to make a quorum over in public safety. I'm gonna let you go because the alderman from the 18th is lurking outside. Lurking outside. And so we'll try not to go too fast, okay? Oh my God.
The good news is they're probably on 95% of this.
We'll be back.
Okay. Even if you know it, it's a good refresher course.
And the director will tell you, I was 100 for 100 as an investigator.
All right.
He nailed them. He did.
That's good. But all of us should
And
know
never
this.
lost an appeal.
Okay, great.
All right.
Okay.
Bet the top.
Mr. Franks?
All
Mrs.
right.
Donaldson?
Donaldson.
Okay.
Yes. Sylvia is our employee relations manager, and in order to kind of give you a full scope of what she does, again, her unit is responsible for investigating any kinds of EEOC complaints that come in for civil service employees, complaints from the Missouri Commission on Human Rights, any kinds of Department of Labor issues. She also administers the citywide family medical leave program. She does all the drug and alcohol testing, and we'll be meeting with Alderwoman Tyus and myself and the police chief and Judge Jimmy Edwards next Tuesday to discuss updates and to get feedback. She does a number of different duties in her capacity, but really I think it's the most complex unit of the Department of Personnel. We have governing Department of Personnel administrative regulations. Who's not here today is Dell Jones. She's our training and organizational development manager. She makes sure that every single new employee has to go through the new employee orientation class. And during that class, they are advised of their rights. Particularly, we hit these important ones with the drug and alcohol policy, when the people have to sign the form on initial employment, and also about the harassment policy, the anti-harassment policy. They are also given instruction on the EEOC policy and a number of other policies. So they get that when they are first made employees. And of course, all these are online. In addition, we do supervisory training that is mandatory. And that is given frequently. Out of the next 3 months, July, August, September, we're giving 2 classes. So we do that training. I will also say that because we have a lot of career seasonal people, or just seasonal people who come in the summer that aren't familiar with the city process, we tend to have a little bit more problems with them. So we have gone on site to provide training. I think Sylvia's done that before as well, and it's a big success. The Director of Parks, Recreation, and Forestry has asked for it. We've done it before in streets. So we go out and bring this training on site so that people understand what they can do and what they can't do. So we also, I will say, do very thorough investigations. One of the things that Sylvia has done is established a fantastic relationship with the EEOC and the NCHR. Because we fully investigate every single complaint from cradle to grave, they tend to have a more positive resolution for us. And, we have objective people, we have
Let
diversity.
me stop for a minute. What's NCHR? So you use?
I'm sorry, Missouri Commission on Human Rights.
Okay, MCH. I thought
Yeah.
you said N. I knew what that was. Okay.
Yeah, because people can have a chance of either filing, if they are protected under Title VII, they can file under, in state, which is the Missouri Commission on Human Rights, or they can file with the EEOC, or oftentimes they will dual file, and then those agencies determine who's going to investigate it. We brought along some statistics as well as the governing administrative regs. We also brought along our policy on grievances, because if an employee is grieving something, maybe a relationship with a manager, etc., or working conditions, or something that does not necessarily involve protected class status, then we will follow that through the grievance procedure, and it can go up past the department head to myself. And then I have charter authority to resolve that. And I've also finally brought a copy I brought the copy of the statistics. And what I thought was interesting, and I'll give you plenty of copies, Alderwoman, to send to the people who are not here. It shows the copies of the statistics which were provided by Sylvia for the calendar year 2017. And it shows you it'll break down for you exactly what the nature of those EEOC, NCHR complaints are, what the status are, how many we've closed out. It's very, very interesting. And we've also brought along a rolling calendar year. So we'll be able to compare the number of what we've got from this year versus the calendar year, and it'll help us address any kind of trends that you might see in terms of complaints that are filed. And then lastly, we've brought along our actual procedures internally for the EEOC, NCHR complaint procedures, the kind of instruction that Sylvia gives her staff. And I think that's very interesting to see how formalized it is. I want to recognize Sylvia because under her leadership, we have been asked to do investigations in other offices where we don't even have jurisdiction. The Court and Bank, the 22nd Circuit had enough confidence in us to ask us to review all of the prior sheriff's EEOC NCHR complaints. So she did that. We've done it for the Board of Elections, which just recently resulted in a big judgment. The summary went in front of the governor himself, and there was a consent decree. We have done it for Jennifer Joyce. I've not yet been asked to do it for the new prosecuting attorney. So we do training as well as investigations upon request for other city departments. So, I'm very proud of the work that Sylvia does. She's does just an exceptional job.
I have a question. Let's slow you down. I heard all these people, but what about elected officials?
One of the areas where we'll address, and
Well, I think we need it. Okay.
I've got something here, which is it's just the amendment that was introduced by Alderman Howard to the very good board bill an ordinance that Alderman Williamson put forward on the whistleblower. And what was important about that is that we have to have a mechanism whereby we can hold elected officials accountable as well. Well, we've got the Ethics Commission, and that is properly the place to file complaints about elected officials. The only thing that we were asking for is that instead of CREA, which has no statutory or ordinance authority to investigate, the Department of Personnel was willing to take over that responsibility for doing the investigations that fall under these categories.
Okay.
So hopefully that board bill will move forward at some point. But the one area where we don't have authority, as Alderwoman Tyus has stated, is that those people who are in accepted positions, they're in the classified service, but those would be the political appointees, the department heads. I don't have authority to investigate them unless it's for political reasons. If it's political interference, the charter as well as the civil service rules give me the authority to investigate, and I have done so. However, if it has to do with anything else, I don't have that authority, and that is something that certainly the Whistleblower Act could address, or some other revision that the Board of Aldermen would see fit.
So let me ask you a question. Do you see this being something that we could address with an ordinance, or do you think we would have to do some kind of charter change?
No, I think it could be done through ordinance, but
Okay.
again, I'm not an attorney, so I defer to,
I
any
will.
legal opinion. But I believe it could be done through ordinance, yes.
Okay, and do you think this is something that needs to be addressed?
I do, I do, because what happens is sometimes we'll get complaints from employees about a department director, and I can go to, the mayor's office, or Darlene's people, the comptroller's office, or even about a Board of Aldermen's employee, et cetera. I
Exactly.
don't really have any authority to investigate unless I'm asked to do so.
So let me ask you a question, just speaking to the Board of Aldermen. So our employees are kind of at will, because we have to hire them every year, 15
Correct.
votes, okay? So are they counted as an accepted position? Is that-
No, they are not. They are
Okay.
totally different. They're not in the classified service. Any job class in the compensation ordinance, which includes the accepted positions, are considered in the classified service.
Okay.
And that's what's addressed by the charter and by the compensation ordinance.
So, but I'm trying to understand, so you could come in and investigate a complaint from one of our people who works here, or you could not at this point?
Only upon invitation by the Board
Okay,
of
so that
Aldermen.
needs to be it, because who in there, if they're harassing somebody, they're not gonna invite you to come in if it's the big boss, you know what I'm saying?
Correct.
So I think if you have that authority for everybody else, that we should not be giving you the authority for everybody else and then keeping a little bit for ourselves, so you're saying that under this ordinance, we could address the Board of Aldermen also?
I believe that it could be, I
It
don't
could
know.
be written up
It could
in a
be
way.
written up,
I
yes.
know you're not a lawyer, I'm just kinda, right, because, I think that everybody needs to have somebody to hold them accountable and be able to investigate them.
Correct.
We don't wanna leave loopholes, especially in light of the Me Too and other things that's been going on, we could've just tightened it up.
Correct.
And then, if we get proper investigations, then of course, we won't have to worry about it. You have something to say?
Yeah, just a few questions. I guess like on your supervisory classes. So if an employee, if they're working for, forestry or what have you, does the manager have to request them to go to those classes? Or could they just say, I would like to attend them? They still have to get the okay from their superiors to attend those classes? Is that how it works?
Yeah, that is correct. We do have, again, for supervisors, there's mandated classes, and also the new employee orientation is mandated, and then we have the code of conduct, which has to be signed on an annual basis. And it's my hope that if the whistleblower ordinance is amended to give the department personnel the authority to administer its section of it, we would then make this part of our new employee orientation. They would get a copy of the ordinance, and then they would have to also get a copy of this on an annual basis with their service rating, just like the employee code of conduct. Because I think there's a lot of important stuff in here. And at this point,
Wait a minute, did you?
I'm sorry?
No, if you finish, go ahead. You finish.
the other thing I
have
wanted
more
to
questions.
say is that in order to allow people the opportunity to have several avenues for complaint, of course they can always go to the EEOC or the Missouri Commission on Human Rights. However, they also can go directly to the Department of Personnel, to Sylvia's section, if they don't feel comfortable, or they can appoint the infraction with their appointing authority, or we have diversity counselors. And I'll let Sylvia briefly speak on that if she would.
Then that might be the one area that, excuse me, that we need to tighten up a little bit, because we do
Would you
have
like
diversity.
water?
No, I'm fine.
You
It's
sure?
just yeah,
We can get you some water.
I'm good.
Okay,
Thank you. We do have diversity counselors in all of our operating departments, but a lot of them have fallen off the radar and no longer understand what their responsibilities are. So one of the things that my staff is planning to do in this current fiscal year is to do some training for diversity counselors. We've already prepared documents to send out to the appointing authorities and ask them to appoint a new diversity counselor, or to at least review the person that they have and determine if that's the appropriate person, if not, to appoint someone else, and then we can do the training for them. And the diversity counselor is kind of a good mediator between our department and the operating department, in that if an employee has a problem and they think it's something, they need to either file a grievance or an EEO complaint, and they don't really know, what the diversity counselor does is explains what the policies are to them, gives them copies of it, and helps them to make a decision about what is appropriate. And they stay in constant contact with our department so that they have the right information, but we just need to update that list, and to do some additional training for those people. So they're kind of our eyes and ears in the operating departments, just to make sure that the employees know this would be more appropriate as a grievance, this might be more appropriate as an EEO complaint, and here's the person you need to call and contact. So they have someone they trust in their operating department to help them.
So when you have a diversity counselor, there's somebody that already works for the department, and then the department head appoints to do this, so this is
Yes.
extra kind of duty?
Extra duties, yeah. So it's somebody that's trustworthy, that employees are comfortable talking to, because sometimes the content of those complaints is really fairly serious, and it might be fairly personal. So it has to be someone who can at least hear a little bit of what their complaint is, and then direct them appropriately, so they're
Okay,
appointed by.
so if they become the diversity counselor, is there a way that the appointing authority or the employee could then, try to control what they report?
I don't understand you.
Okay, so if somebody makes me a diversity counselor, and then what if I find problems there?
Mhm.
Is there a way for retaliation to be directed toward the diversity counselor?
Not really, because all they're doing is directing people
Okay.
towards us.
Okay, so they're
and
not
towards
really
the
pointing out
appropriate
who's doing wrong or anything, that would then still come from the employee who would talk to you directly?
Absolutely, absolutely.
Okay, did you have a question?
Yeah, so the diversity counselor really doesn't have to know the detail of the problem that employee is having with a certain employee of the department. They can say, look, I need some counseling, I like to go to personnel to file a complaint. In other words, I mean, if you don't trust that, like you said, that diversity counselor in that particular department, because you may be friends or close to the person that's being offended, or what have you, so you don't wanna really, open up. So is that possible, just
And they don't have
without-
to go into great detail.
Okay.
They can say,
Yeah.
someone touched me when I was in the cafeteria,
Okay,
Yeah.
and I feel that something is really wrong. Who am I supposed to make this complaint to?
okay,
And they might tell them, talk to your supervisor and let it go up the chain through the operating department. They might also counsel them, but you also know that you can call the department personnel, here's their contact information, and make a complaint. So I don't have to give the details
Okay.
and say what's going on. I
Right.
can tell you the nature of my complaint, and then that would help them to
And-
either do it in
Go
the
ahead.
department or come to
And
us.
my last question is, okay, if I got a drug problem, or if I'm alcoholic, and, and my performance at work, you can come, you smell my breath, you smell alcohol, or, if I'm on drugs and having problems. I mean, what happens then? If that person, before they really get caught up, I've heard this, I'm not true this, they say, look, I got a problem, I need help. I need to go ahead and get some counseling because, I'm alcoholic, or I'm dope head. Now, can they do that without being fired? Or what,
Absolutely.
if I don't do that, then my supervisor fires me because I have a drug problem, then there's really no repercussion if they do release me from the job because of my,
They can
drug.
always contact us. The city has the Employees Assistance Program, and that's one of their major functions. They will either deal with employees that maybe fail a drug and alcohol test. If they fail and it turns out that they have alcohol in their system, we mandate them to go to EAP and go through counseling, and they stay with EAP for a year, so that's mandatory.
What's the EAP?
The Employees Assistance Program.
Okay.
And so we mandate, but if an employee is having a problem with drugs or alcohol and they self-disclose that either to myself, sometimes we get it because they ask for time off for family medical leave, and then we'll see that that's a voluntary disclosure. Or they might be comfortable enough to go to their supervisor and say, this alcohol issue has gotten a little out of hand, can you get me some help? The answer is yes. That's what the Employee Assistance Program is for. And it protects them in their job because now they're doing the right thing, they're getting help, they go to licensed counselors and therapists that are part of our program that the city pays to have, and so they can get some assistance and their job is protected. I do want to remember, or help you to remember, that one of the first requirements that EAP counselor is going to tell them is, I will not use, I will refrain from whatever. And our Administrative Regulation 120, which is our drug and alcohol program policy, does say that if they are in violation of their agreement with the counselor, then they're subject to termination. So it will protect you if you just want to get some help and get your life together. That's exactly what the EAP is there for, and it will protect you, but you have to stay in compliance with your program. If you fail out of compliance, I normally will give them one chance, because I'll have an EAP counselor that says, Joe Blow missed his last appointment and I don't know why. And I'll call the department and say, you need to make sure Joe Blow contacts them, because if he doesn't, he's going to lose his employment because it's required by policy. And Joe Blow will usually call in 5 minutes, because he just missed the appointment, he had a problem, and so we make sure he gets there.
All right, let's say if I'm on heroin, something like that, and I need 30 days shock treatment.
Mhm.
So if I have to go away and drive for 30 days, with the city of St. Louis, will that be kind of like workman's comp? Will I still be able to get paid, or I just?
It will be family medical leave. If
Okay.
they meet all the other eligibility requirements for family medical leave, that will be family medical leave. And typically, if they go through the EAP, those counselors there can prepare the paperwork, or when they go to whatever healthcare provider, whatever agency they go to, they know how to prepare family medical leave certifications. And so that is a situation that will qualify for FML. And while they are on family medical leave, the city continues to pay for their health care, our portion, the portion that the city pays, and then they are responsible for paying for their portion, but it keeps them with health care, it protects their job while they're on FML, and they can come back once they've resolved their issue. So yeah, we do have safeguards for that.
No. You ask, this is what we're here for.
But my last question is, some of the classes that you offer, the personnel offers, so can we attend them as all?
That's
Yes.
what I was gonna ask that.
I would say,
But we have.
Absolutely, and we would even bring it on site.
That's what
for
I was
you.
gonna ask.
Okay.
We would be
Right.
happy to do that.
Right.
Okay.
One of the things I want to say too is that the city's been very progressive for a long time, and even if you're terminated for a drug and alcohol related offense, if you show us that you have completed an approved treatment program, you're then eligible for rehire.
Okay.
So we understand about second chances. So that's an important component, unlike certain agencies where you would never get help, and you become unproductive to society. Here, if you have this and you screw up and you get tested positive and you're fired, you can come back to us if you show us that you've been through an approved treatment program.
And is that counted against you in any kind of point system or
No.
anything?
None at all.
Okay.
That's all I have.
All right, and I'm gonna let you get back with it. I had a question. So if persons do not, trust the diversity counselor, they can just proceed right around the diversity counselor?
most definitely.
And go to whoever they think, who would then, if they came to personnel and you thought it was something else different, you would then point out where they're supposed to go?
Absolutely, we do intake every day, all day. So
Walk-ins.
if anybody has, if they
Okay.
have a question or a concern, they can always visit us or give us a call. We want to put the resource back in human resources. We are a resource
Right.
for city employees, or even if they're not city employees, they might be in some of the county offices and they just want some information. We want to be a resource. It's much easier if you talk to us on the front end and we counsel you in the right way to go, then there'd be a problem down the line and we haven't been able to assist you.
And how do the employees know where they're supposed to come to? I mean, as far as, and maybe when I get your handout, so in this booklet that you get when they first are hired, is there something that says this is how you complain, or this is
Oh,
what you do?
yes.
Okay.
If I may,
You could, yes,
Alderman
put them out, and, right, she's gonna put them out.
Oh, okay. I made, I think 9 or 10 copies in.
Okay, that'll be enough. So we got 1, 2 people sitting there. Right.
And again, we do go into detail in the introductory new employee orientation class, and then the supervisors are also certainly advised.
Oh, she just passed me by.
One thing I wanted to say also even about our grievance policy, the unions helped us. Jeff was there with Joanne. We had a grievance policy that used to stop at the department head level. Well, that didn't do any good, because what if it's your department head?
Exactly.
So it comes to me.
Right.
And we get very few grievances now because they're scared, because what happens is if Sylvia calls down a grievance panel, that panel is facilitated by employee relations, but there's one member of management, one member from labor, and they're an actual labor official, and then an employee level person sits in an informal hearing, but they have to actually present evidence, goes back and forth, it's actually like a hearing, and then that recommendation comes to me as director of personnel. And it's not a pleasant process, and sometimes when they take this grievance, they'll find out that there are maybe racial or gender or other issues that come to light. So then they get funneled over to Sylvia for full investigation. So
Okay.
it's a big stick that the appointed authorities do not want to get called down there, and it's encouraged them to resolve things more amicably. And Jeff might have something to say about that as well, but I think we've really,
Utilize the process, so that's working.
Okay.
They was gonna come in from.
Okay, one more, and I have one that didn't. So, now here's something, what happens if the problem is in personnel?
if it's in personnel, I end up dealing with it myself. If I'm the problem, then the Civil Service Commission is the body that could officially investigate me. And the other thing is that, as always, just as my budget, I can always get called over to the Board of Aldermen. So, but I think that that's one of the beauties of the Whistleblower Act, is it includes everything. You know, there's certain officials, you know, that are responsible for conducting investigations. So if it was in personnel itself, or myself, or my deputy director, whatever, then somebody else, like the comptroller or a different body, could do that investigation as an alternative.
Oh, okay, you had a question?
Thank you. Yeah, on those investigations, and like you see, a labor person comes over, somebody like Jeff, you know, and the majority of the city employees are civil service. So we do have the patronage, the county offices, like recorder deeds, treasurer, sheriff, you know, license collector. So if you have a conflicting situation in those offices, will labor also be there, even though they're really not civil service? They kind of come under a county, you know, the state statute. Is there a difference of handling those people or those personnel
Yes.
problems?
Yes, they would not fall under our jurisdiction, Alderman, and they couldn't access, for instance, our grievance procedure. You know, they are not covered by any of my department personnel administrative
So
regulations.
they couldn't really come to you?
They could come to Sylvia for advice,
Well, right,
or
okay.
we've certainly been invited. I mean, as I said, Jennifer Joyce asked us to do investigations and also to do training on sexual harassment. You would think attorneys would be better, but that's not the case.
No,
And we've
not
given
necessarily.
assistance and done some investigating for the Board of Aldermen. We've done training for the license collector, for, in the past for collector of revenue. We've done classification studies for different people. So we're here to serve. So as long as we're invited in, it's just that my, you know, decision then would not be binding. It would be up to the respective bodies.
Gotcha.
But that's again, the beauty of the Whistleblower Act, is it gives ordinance authority
Right.
for the board to take action as necessary.
So though, I'm sorry.
Oh, well, I'm not-
So, but if we really wanted to address this, the state could give authority to you to investigate if there was a state law that said? Or do you think that would be cross-pollination with two different?
It probably would, because the Missouri Constitution prohibits
Right.
the state legislature from getting involved with the powers,
Right.
duties, or
Okay.
compensation
Right.
of a charter city official, which is myself, yourself, et
Right.
cetera.
And I think that's the whole big old fight we just had with the treasurer's office about them being able to direct a member of the Board of Aldermen in the city to do something. So then the best we could do is then just have the people bring you in, but then they would have to do the final analysis of what should be done, right?
Correct. We
Okay.
make recommendations, and in terms of our process, also for educational purposes, when we do these investigations, you know, they're kept as confidential as possible, but they are full investigations, and the appointing authority gets the results of the investigation, and the employee gets the results of the investigation. So that's an important fact, because then if they choose to take that further, they can do that. They can file with the EEOC or MCHR, but in many cases, the problem gets resolved informally. We do have a lot of activity, and the statistics show that I think Sylvia's area has done over 150 investigations in the last year. So, and unlike other organizations, and I'm defer to Sylvia, but we've actually not seen that explosion of Me Too, because we've been doing these investigations all along. We have a very low tolerance for this kind of jazz. Sylvia had one shocking case, the ladies here, but a lady came in as a walk-in with a picture of her supervisor nude.
Wow.
And I about fell out of my chair. I'm too old for this stuff. But the young lady had to investigate it, and as it turned out, both employees were actually involved in a consensual relationship, and both people ended up losing their jobs. So a lot of times, we had another example I shared with the chair before, where there was a person in EMS, and two of his co-workers accused him of sexual harassment. Well, we found out that actually they were both interested in him and lived together and colluded to make up these accusations against him, the poor guy. But I just want to say thank you again to Sylvia, because what we find out is very, very interesting sometimes. And, that's why I consider, Sylvia's area probably the most high-risk, important section of our department. Because you can undo a lot of damage in different areas. If we make a payroll mistake, we can correct it. If we screw up on your classification, we can fix it. But these are people's lives, and it exposes the city to a lot of potential liability. So
Right.
we work very closely with the city councilor's office in resolving these issues.
Okay, so that's sexual, racial,
General harassment,
general harassment, physical, any of that, all comes under this.
correct.
Right, so, I'm trying to just understand the whole procedure. So say I come in and I make a complaint, somebody's harassing me, okay? I say my supervisor or somebody has assaulted me, okay? Not sexual, but physical. So I would come in, and if I went first to my, the first person I would have to go to maybe is the diversity counselor. Would
No. They're there to assist, but they don't have any real authority in the
Yeah, but I'm saying
process.
if I
They're
went to
there.
the diversity counselor, what would the diversity counselor tell me?
They would probably point you to me and
Okay.
tell you to give me a call and find out where you needed to be. Is this something, because depending on what took place, if it was an assault, it might be something that the police need to be
Right.
involved in. There might be a real,
Right.
a
What
case
if my
that they need to
supervisor
be
pushed
involved
me?
in. Then that still could be assault. So
police,
it just
right,
depends on the
exactly.
content
Assault
of
third
what
at least,
really-
or maybe
absolutely.
second, right.
And we would kind of usually contact the city councilor's office. If we're not sure about that, I'll give one of the city councilors a call, and they might say, yeah, first of all, tell them to make a police report.
Okay.
And then we'll go ahead and investigate and
What
do
if the
whatever
person
needs
has
to be
waited
done.
too long for a police report? Because I think it's sometime a year, and they come to you because they've been scared, okay, because they need their job. And so I've been scared until now I feel like I need to this is continuing and I'm being harassed, and so I need to come to you, but I can't do a police report. So what would happen then?
We look, in a case like that, we look and see if there was a continuing pattern, because we don't want anybody to come and tell us, we have a limit into how far back something should have occurred before you tell us. So
Okay.
if this happened back in January of 2017, that's really past our limit. That might even be past the limit that the EEOC or the Missouri Commission would even look at. So we're not really, we do have a rule on that. But if there's been some continuing
Okay.
pattern of discrimination, maybe the big incident happened last year, but then there's been a continuing pattern, and the employee can tell us, just as recently as 2 weeks ago, this is what my supervisor did to me, then that makes it a whole process, and we can
Right.
then investigate at that point.
So then let's just say it's a pattern, and so then, I'm just trying to walk through the steps. You guys know it very well. I'm trying to,
Sure.
okay, so you, assign an investigator to
I'll
it?
assign one of my staff to investigate. I will usually vet it first and kind of go through the information and see what the content of it is, and see which of my staff members would be best to investigate that complaint, and then pass it to one of them. We always remind people that when they make a complaint against anyone in the department, one of the first things that we're gonna do is we're gonna send information to the appointing authority. And we're gonna tell them, I have this complaint from your employee. Here's a copy of the complaint. We need a response from you. And that will spur the appointing authority to now do some investigation and find out what's going on. It might resolve it. They might do enough investigation and send us a position statement that we can use then to kind of resolve the complaint. But if it does not do that, that's at least the employee side, who is the complainant, and then we've got a respondent side, and then we can start an investigation at that point. And we just determine who we need to speak to, what we need to do, what evidence, what documents we need to see, and we just carry out a complete investigation.
So when you send it to the appointing authority, then they are required to do something affirmatively?
They're required to give us a response. They're required to respond to the charges. And sometimes we get, depending on what department it is or the nature of the complaint, sometimes the appointing authority doesn't want to respond. Personally, I'd rather have the department personnel investigate that. And a lot of times we get those maybe from the police department or
It's
somewhere
changed,
else.
yeah, if I may interject, in the past, under the Board of Police Commissioners, and then for a while, The police department, as you know, has had several very large judgments against it for failure to investigate legitimate EEOC MCHR complaints, and they're still out there. So I commend Police Commissioner Hayden that under his leadership, now whenever they get an EEOC or MCHR or personnel-related complaint, they send it to Sylvia to investigate. And it's more of a hands-off because we knew that there were problems in the past with internal affairs. I myself have filed one with, and I'm not happy about it, over 2 years ago with internal affairs, and it's still sitting there. So,
Right.
and I've had that
Because
conversation
people
with
can't
Janelle.
investigate themselves. That's
You
why.
can't.
Right.
So
No
you come
matter
to
how you
us.
think you can, you cannot.
And one of the things, you know, some people say, oh, well, the director of personnel has too much power or whatever. There's a reason for that. I have subpoena power, and so I can subpoena both people or documents. And if they fail to comply with that under Article 18, I can have an appointed authority removed from office. I've only had to threaten that 3 times. But it's very important that someone have that authority to be able to force compliance when necessary to investigate sometimes these really egregious acts. And sometimes they do involve the appointing authority.
Correct.
So that's why the system is set up that way.
Okay,
And
so-
again, for the end, I'm sorry, ma'am, I did include here, I know it's kind of boring reading, but Sylvia did a
No,
nice
it
job.
isn't.
This is sort of like,
Is that a different handout?
this is at the end, no, these, you each have these, and these are our internal procedures, sort of like a simple flow chart of how our intake process works and what actually happens. So I thought that would be helpful for you.
Okay, great, okay, okay. So, okay, just going, finishing, so they're required to respond, okay? So when they respond, the appointed authority, they then go talk to the person who's been accused. Try to get their point, and do they respond in writing, verbally?
They respond in writing to us, absolutely. And we use that to kind of determine a little bit of the content of what our investigation is gonna look at. Some appointing authorities are really good and do very thorough investigations. They have witness statements, they have all kinds of good supporting evidence, all kinds of exhibits, and we can use that as the basis of our complaint. And we'll look at that and determine, they covered it all. They asked all the questions that we would have answered. And then we might look at that and say, yeah, but we need to talk to this person. We just determine if there's some additional investigation
Okay.
that we need to do at that point. And once we've done all of that, what my section does, we make a recommendation in writing. We'll give the investigative report, all the exhibits, all the documentation to the Director Frank, and then make a recommendation as to what we think needs to take place, whether or not there was a violation of Administrative Reg 103 or 113, or if there was not, if there's not enough evidence for that. And then based on that, we make the recommendation to the director, and after he makes a determination, then we prepare responses both to the complainant and to the appointing authority.
Okay, so, let's just say you found that the person has been assaulted physically. And you got witnesses and things, and they were assaulted physically. Then what happens?
Well, we don't necessarily, we would go to our workplace violence policy, Administrative Regulation 142 might be involved there. And it also does say in there that, you know, if someone has to make a decision whether or not authorities need to be contacted. And depending on the nature of the altercation or the physical contact, then someone is going to make a decision, usually the appointing authority. And very often the appointing authorities know to call the city councilor's office to get some direction. So they may make a decision. If it's something they're not certain about, they will contact the city councilor's office and make a decision as to whether or not the authorities need to be called in on some kind of an assault situation.
So, okay, so what would be your range of recommendations, I guess, I also wanna know. So could it be, do we offer anger management, or?
We do have classes
Okay.
on that, yeah. And the recommendations might be anywhere from, we won't necessarily say you need to discipline this person, but the director's letter might say something to the effect, you need to consider whether or not disciplinary action is appropriate, because that's the appointing authority's decision and that's their process. So the director's letter might say that. It might also say, we recommend that everybody take these training classes through the Training and Organizational Development Division. And we recommend, you know, something on that order, that there's some additional training. There might be some recommendation that you consider discipline, and those kinds of things.
For something real recent, I just signed off on, one of our divisions failed to really do a thorough investigation on an issue. And so one of my recommendations was that we offer on-site training for the management team in this division, again, as a refresher on these policies and procedures.
Okay, so if it's, so you don't recommend termination, you just would say you need to consider termination as an
You
option.
need to consider
And then at the end of the day,
disciplinary action.
it's the appointing authority. So, what if the appointing authority says, I don't care, and we're gonna sit around and let it happen anyway? Doesn't that then, as an attorney, to me, that's putting the city on the hook?
It
If you don't-
does.
Sure it is.
Yeah, okay,
Sure it is.
because before, you might just, if somebody might sue the employee, but if the city doesn't do anything about it and they've properly turned it in, as an attorney, I see that as now the person can sue the city, because we've put our stamp of approval through color of authority on that. Is that how you see it? And if you don't wanna say legal opinion,
No,
okay.
we very
I-
seldom have appointing authorities that don't take the director's recommendation, and I haven't seen in the
It's a
period of time
dangerous
that
thing
I've
to
been
do,
there.
because then they can take that, if you have a recommendation from the director of personnel for this city, says that you have violated, we have found this, they then can take that to MCHR or EEOC or their own private attorney, or file something directly, under Title VII with, in state court. But also, then they usually get correspondence from me. If I see that something is not happening, and I will copy their boss. And I've had to do that recently with a family medical leave issue, where, suffice to say, the management team, high-level management team was not responding. So I went to the director and also stated, unless you address this, I'm going to insert myself. I also review and approve all discipline. And if, now Kathleen Tanner is one of the deputy directors reviews it, but she will consult with me and I review all dismissals. And if we recommend that serious disciplinary action be taken, which does happen from time to time, and it does not, then I get back into contact with the appointing authority and say, I believe this is inappropriate. We had a police officer who refused to take a drug and alcohol test, and under our policy, that's mandatory dismissal. And this was under not under Chief
Right.
Hayden, I want to clarify. And I sent it back. I said, I'm not approving this one-day suspension, because I think this is insufficient, it violates the drug and alcohol policy. You need to rethink this.
Even if you refuse to do that when you are on the road, then they take your license immediately, you can't, so. Okay, so now, if it was a thing with sexual harassment, do we send people to some kind of class for that also? Or racial insensitivity or harassment? Do we have classes on all those things to familiarize? Okay.
We do, and they're offered frequently.
Okay, and you said you would be willing to bring this to the Board of Aldermen?
Absolutely.
Okay,
Chair, we've even done one-on-one counseling. Sylvia has done that
Right.
very graciously with high-level officials that needed it.
Not you, Larry.
No.
okay, I'm sorry. So we've been continuing, Alderman from the 26th and I have been asking a lot of questions. Alderman, do you have any questions?
I guess but I know a lot of our classes that personnel provide is mandatory.
Correct.
So, and I think sexual harassment, that's still a mandatory one,
Yes.
and things like that, so they are mandatory, especially new people and then people, and then once you take that, are you obligated to take it again, or like as a refresher course? That's up to you, I guess.
Yeah, we recommend.
Right.
One of the things that we might think about is having people take the class, every few years. We do that, for instance, with defensive driving every 3 years.
Yeah, I think that's what I
And because
did.
things have changed. I'll say this, even in terms of like the Missouri Commission on Human Rights. It used to be that it was very difficult for the city to defend against those cases because race or sex or whatever only had to be a contributing factor. Now the law has changed within the last year that it's a motivating factor. So we keep ahead of the curve in terms of reviewing case law and as well as legislation to make sure that our supervisors are trained and are up to date on the most recent law. I was appalled. I saw a very large organization that we have, Anthem, and our insurance provider, their EEO statement is incorrect. It doesn't have GINA, which is the genetic information you know, and I can't remember what's the end.
I know the end
Non-disclosure.
is non-disclosure.
But it's basically protecting genetic information, and I tried to get their attorneys to put it on their letterhead, they wouldn't, so we put it on our own and attached it. So you would think that a corporate entity that large would be up to date, many aren't. So that's something that we rely upon Sylvia to do, is to keep up to date on any kind of changes. For instance, with family medical leave, it now falls in with ADA. You know, we have instances where we have something called the joint regulation, I didn't include here, but if we're getting ready, if an appointing authority wants to terminate someone because they're unable to perform physically the duties of their position, we require them now to first go to Commissioner Newberger, who's the Commissioner on the Disabled, to see if a reasonable accommodation can be made. Or if the person just needs additional time up and beyond family medical leave as a protected medical leave of absence. We had a lady who had breast cancer and she was undergoing chemotherapy and she needed more time. And the department was wanting to fire her, and I said, not so fast. You know, if her doctor, her oncologist says that in 3 months she can come back to work, you know, and I ended up, this person resigned. She just didn't want to come back after the ordeal. But there are all these kinds of safeguards in place within our system that require my review or one of my deputies' review to ensure that we are also protecting people under ADA.
And I will say this, I guess, 97, when I worked in personnel, I mean, they have come a long ways on a lot of harassment cases and putting together. Sylvie's done a fine job, and it was Roz before you, and I don't know who was in between if there was, but I mean, personnel has come a long ways under the direction of Mr. Frank from Bill Duffy. So I'm, no, seriously, I mean, just move forward and has updated everything, I think.
agree.
You know, Bill was kind of stuck maybe back in the
Right.
We're gonna
60s.
just talk about, we're gonna say the former personnel director.
Farmer personnel director. But, no, it has really come a long ways, he's reorganized. I think they made changes in policies that really helps and protects the employee more so than it used to be. So,
And a lot of credit goes to that, Alderman, to the unions, because, you know, a lot of these policies, like we updated our disciplinary policy, our grievance policy, our workplace violence policy, and the collective bargaining policy, all was done originally with our first 10 unions, and it was facilitated by the Federal Mediation and Conciliation Services. Jeff was part of that along with Joanne. And our next step is I've got, with Joanne Williams, I've got an administrative regulation on hold that will help inform employees about the the sliding scale mediation services. We're really excited about that because we feel that a lot of times these are just interpersonal issues between a supervisor or a coworker. It's not really something that's an issue that's best served under the grievance. Maybe these people just need to sit down and talk. So I think that's our very next step. I believe it's a grant located under the Human Services Department.
Yeah.
But, and Alderwoman Carol Howard worked with Joanne Williams. They worked very hard on getting that program up, and we're hopeful that we've got the administrative regulation, and it's just gonna be, again, information for employees that we can talk to, that if you have this kind of conflict with a neighbor or a policeman or a coworker or supervisor, and you don't wanna file a formal grievance, and you don't want it anywhere in your personnel file, this is another way to do it.
no, and like I say, I think personnel has come a long ways from 97 to when I worked here from 97 to 2010.
That's good, thank you.
Okay. Mr. Alderman Coler, do you have any questions?
No, I do not, sorry.
Okay,
Go ahead.
you have any questions?
Yeah,
Alderman?
I just went on a sexual harassment. I know some departments, like when you get hired, fill out your paperwork, not all, but some have you sign a document explaining sexual harassment, saying that, so if I sexually harass somebody or they sexually harass me, when it comes down to it, that person or I can be sued and not the department. Is that part of the policy too? you know, and keeping the department from being sued or being put up under a lawsuit. It's just between the two employees. You understand what I'm saying?
Yeah, it is not, we do not have any type of policy about, we certainly have nepotism, but we don't have any policy about romantic relationships. Some corporate entities
Do.
have you actually sign a statement if you are involved in a romantic relationship to help protect the organization, and then if that ends, you know, you have to also notify them. I had conferred with the prior city councilor about that, and they didn't wish to pursue that. That's something that certainly could be done. And one of the kind of disturbing things about a recent Supreme Court decision is that it states that some states can now, and organizations within those states can bar class action suits from employees. So I think we're gonna see
More of that.
more of that, right. But we don't have any kind of restrictions about that. We certainly caution our managers, though, about being careful, because even if you're just friends, you can't give that appearance of giving preference, you know, to certain employees, or you've got a grievable situation or something worse. But that's a very good question.
Yeah, and in your sexual harassment classes, I guess you guys instruct or explain, you know, you may be being nice to a young lady or what have you, and say something, and she may exclude it as being, you know, you're trying to hit on me, it's sexual. So do you guys really kind of explain, like, okay, you look very nice today, could that be sexual harassment? I like the dress you have on, or, you know, whatever it may be. So on those classes, do you really kind of, is it a cut and dry where you can say, hey, that's saying this is not, or saying something like this could be excluded as being sexual harassment? So do your classes really teach that?
We may not go to that detail, but we do give examples of what kinds of behaviors or what kinds of things might be said, whether they're touching or words that you say, or, you know, looking a person up and down. We do talk about those things, and we just ask people to be mindful. Because we do remind them that sometimes what you might mean innocently, sexual harassment, is all about perception. And you meant it innocently, but to me, it felt inappropriate. So we just try and remind people, think about what you're saying, you know, compliment the dress as opposed to how she's wearing the dress. Or, you know, compliment something else, or just leave it alone, or just saying, have a nice day. So we just remind them of
That's
that.
better.
Yeah, we remind them of that, but we don't have any
Exactly.
prohibitions to say you can't do that.
Yeah.
Because someone might not be offended about it. Sexual harassment is all about perception, what it feels like to me,
Gotcha.
and not necessarily your intent with what you said.
We have a pretty aggressive policy here in terms of what we consider to be harassment, what we discourage. And I'm sure Alderwoman is aware, you know, if you actually go to court, it gets to be much more difficult in terms of like hostile work environment. It has to be so prevalent. There's one famous case I know where the person was exposed 70% of the time to horrible posters and pictures of women and all this stuff, but this female had her own office, and so the court ruled that it wasn't pervasive because she had her own private space. We would not tolerate that within our organization, but the legal standard, you know, really is for pervasive. It's very, very difficult to prove, and then it needs to be unwelcome. So if, you know, if you're a female and you're hugging everybody or saying this and that, and then all of a sudden, you know, you need to make that statement that, please don't do this, it makes me uncomfortable. And that's something we talk about in the classes. It is an ongoing dialogue, it's a case-by-case kind of situation, but we do give examples of behaviors and speech or et cetera that is provocative.
Thank you. That's all I have.
Alderman, did you have any other questions, Arnold?
No, that's why I kept quiet in personnel.
Well, I want to say, I think that what's uncomfortable, the conversation changes over time. I think it's fluid, okay? What would have been accepted in the 60s, and 70s and 80s and 90s and so on, it changed greatly, okay? I would not, if I was a male, I wouldn't even say, unless it was a close friend of mine, I wouldn't talk about the dress at all,
Right.
okay? How you doing today? You look nice, and keep it moving, okay? When you start getting into the dress and the appearance and stuff like that, it does pass and you look nice. I think that people can perceive it a different way.
It may not offend you, but it
Right.
might offend Lisa.
Right.
You know, it just depends on, like they said, the person, I guess, but it's best to stay away.
And I think the courts are absolutely wrong to rule that if, you have to go through, because even though you have your own office, you might have to travel through this
Right.
kind of, behavior, and that's absolutely wrong, that they would think that that was not the kind of thing that would make somebody feel uncomfortable, because yes, I can go to my office, but why do it's like, I don't hear the N-word in my office, but I have to walk through it, okay, so I think that was the wrong decision.
I used to work for for the courts, and I went into one of the jurisdictions, class 1 jurisdictions, and in their abuse neglect unit, and one of the things that they did was investigate people who would take their children, recommend termination of parental rights, got involved with sexual assault of children, and they didn't even think about it, but they had all these pictures, these calendars of like half-clothed children, like little angelic babies, and I'm like, you're having pedophiles come in here to be interviewed, and you've got naked.
Yep.
I mean, people, and I'm sure it had been there for years and hadn't thought of it that way, but they're all the woman is right. One of the investigations that employee relations did, which is very difficult. I felt sorry for people involved, but there was a gentleman at in one of our county offices, and he was elderly. He was in his 80s, and he made some remarks that over time made a younger lady uncomfortable. And in his generation, that was appropriate speech. In hers, it was not. And it escalated. And after all this happened, and I investigated and we wrote a report to the governor, I just this week got the consent judgment, and it cost him $25,000. Just for, and there was no physical, it was not as serious as some of the stuff that Sylvia sees, but you're exactly right, Alderwoman. The dialogue has very much changed, and now with Me Too, even more.
Well, and I think that, so people are used to doing that, they really resent the change, okay? And I'm just gonna give an example of TV. Bill Maher I used to watch, and he really resents, he says that the younger generation, they're too politically correct. But what I hear him saying is that, well, we've been used to being able to make these jokes, and they were funny to us, but they were never funny to other people in the first place, okay? So what he's calling politically correct was just, I call it a correction of what should never have been acceptable many times in the first place, you know? So, I just tell people, don't say that, okay? Keep it, unless, Frank and I have known each other for 40-something years. We're personal friends, that's one thing. But unless you know it to be a personal friendship, just move it and keep going. And if you wanna be friends outside the office, then do that. But the office, I think, is not the place or the workspace to be all that friendly anyway, as in personal friendly. I have a question about progressive discipline. Is that what we practice here in the city? Is it a progressive
It
discipline?
is a progressive disciplinary system, and it's non-punitive. You know, what I've said from the beginning is we just give enough discipline to get the message across. You don't need to suspend somebody and hurt them and their family for 20 days if you can do a 4-day suspension and get the same point across and say, if this happens again, you know, within a short period of time, you know, you face termination. So it is progressive, but under Administrative Regulation 117, there are some offenses that are so serious that they warrant. I mean, if you push somebody or shove or hit or steal, or there's a number of things that are specifically outlined in Administrative Regulation 117 that warrant consideration for dismissal, and we outline those.
Okay, and also, this is such wonderful information. As I was sitting here listening to it, have you, or is it, and I need to talk to the TV people, to me, this is the kind of course that could be put on TV and run, you know, on our channel, so that people could watch it at their leisure, or do as a refresher course. I would be willing to talk to TV, is it called, what is it now, TV 116, what is it? STL TV, right, okay, because I just think that these are the kind of courses that we should put on TV, and people could, people who are frightened about what they should do, could just go and watch the course, and we could talk about it.
I like that idea. One of the things that we've talked about is that when we have our people who are laborers or tradespeople, and let's say that it's raining for a couple hours, instead of just having them sit, you know, in the shop, etc., we use that time to give them a DVD course, you know, where they can fulfill some of their requirements and can use it for educational purposes. But that would certainly be taking it to the next level. And you know, my training and organization development manager, and certainly this is under Sylvia's province here, like sexual harassment or you know, the other types of things like workplace violence, et cetera, you know, fall under her jurisdiction, we would be happy to do that upon request.
So you wouldn't be opposed to me talking to people about it?
No, not at
Okay.
all.
A number of years ago, we did do a video of Administrative Reg 117 policy, and that was when I was still in the training section. And we did it, and we got it ready. We had them come over and videotape us, and they, you know, went back and did with Lawrence. I think his name is Lawrence. He wound up going back and preparing it for it, and then we changed the administrative reg. So there's some considerable differences in the one version over the other, so we couldn't use it. But that was our entire idea at that point, was to run it on the city's channel so that people always had it and had it available.
Right.
But we just made a few more adjustments to it, so that is something I think would be really great.
Yeah,
Okay.
good idea.
Anybody else have any questions? Okay, do you have any more to
I just want to make sure that in my packet, did I give you the statistics? If
Okay, so what we have.
I think I may have destroyed them by accident. And I'll make sure
I
that.
do have one, I can leave this one.
Okay.
I don't have the statistics.
I can leave this one.
Oh,
Yeah, I
no,
have-
we can just make copies.
Make
She'll make
copies.
copies
Okay,
in the.
great, thank you.
Right.
And it kind of shows, I think it's interesting, again, Sylvia was thoughtful and kind of compared the calendar year versus 2017 versus, you know, July 1st to June 30th to see. And it's interesting, and it is broken down by category complaint, where we're at, how many were closed out, what the actions were they, you know, was it sustained, what did we find, so.
Okay, so we have an alderman here, and so I want to know, Alderman Gunther, did you have any questions? Because I always offer.
Very nice to meet you.
Okay, and we also have some, so if you don't mind, if we have people from the treasurer's office and Mr. Hines from the carpenters, do you mind if I open it up to
Oh,
questions?
absolutely
Mr.
not.
Hines, do you have any questions?
No, I'm good.
Okay, anyone, are you all three from the treasurer's office?
We are.
Okay.
Yes, I'm Shirley Gruchik, I'm the Director of Administration.
Okay, thank you for coming.
And then we're here with Connie Johnson, Assistant Treasurer. who you
I
met,
saw
and
her once
Tracy
or
Diggs,
twice.
our HR Manager. I don't have any questions, but I know Tracy has worked, and myself have worked with the Department of Personnel for many years now, and we've had you come out and do trainings for us, for our employees. Our employees do the defensive driving. We recently have decided to start looking into some videos. Also, we have parking enforcement officers that during inclement weather, it would be great to have some training on hand, so that they're not just, you know, sitting around and using that opportunity to educate and train, so.
I think what we'll certainly do is circle back about your suggestion also and see where Dell is at in terms of, you know, looking at different mediums for training, so I think that's excellent.
I would just ask, is there anything specifically addressing transgender?
Okay.
We had that in federal service with bathroom issues that became, you know,
There-
employed by
there
actors.
is.
And just forward thinking, because it's a reality.
Yeah, I appreciate that question. Actually, the city is pretty forward-thinking on a number of issues like that. We were one of the first cities in the country to have domestic partner benefits. We were one of the first cities to offer transgender benefits. So if you actually need we insisted, before the Department of Labor required it, we insisted that our medical carrier provide for not only the medical procedure for that transition, but also any accompanying type of treatments and medicines, et cetera. It is included in our policy, gender identity or expression in our EEOC, and we do train. And I understand the city's been compassionate. Long before I got here, I heard that we've had several transgendered employees who worked in different departments, and our position is that, you know, if you're transgendered, you use the bathroom that you identify with, you know, in terms of your, you know, orientation. So that would be my position as Director of Personnel. But we do include that as part of our training.
Then what if the employees have a problem with it?
Well, then they would have the ability to file a grievance.
So that's your position. Do you think we need an official law about that? Because otherwise, we're looking at employees filing a grievance, and do we need an ordinance or something specifically addressing it, or do you think your department covers it adequately enough?
I don't know that, I mean, again, the city is so large, and we've got the airport, and we've got the water division, et cetera, and you know, from where I sit at a 30,000-foot level, they may reach Sylvia before me. I don't know that issue has come
I
up.
don't recall it ever coming up.
I don't recall it, but, you know, in terms of foresight, you know, that would, you're better positioned than myself.
Well, I'm just saying, because I'm hearing, what I heard her say was that, okay,
Could
yes, it
happen.
might be good for the transgender, but some
Sure.
employees might not like it. And we're leaving open a grievance process, whereas if this is an ordinance that says everybody gets to use the restroom that they identify with, which I do know it'll be a hotbed for the Board of Aldermen, but
Yeah.
that's what we're here for, that's what we get paid all the money.
Yeah,
Oh, not, okay, by the way, anybody's watching this, we do not get paid all the money. But, maybe we need to have that a law, then that'll take that grievance process away from them, that'll just be, they have a right to do that.
I think that is more of a legislative issue than a personnel issue, in my opinion, because it involves facilities
Okay,
and buildings, you know, which again, you know, come under the auspices of the Board of Aldermen. So
okay.
I think that you're correct, Alderwoman, that would be more something that would be done by ordinance as opposed to a civil service rule or an administrative right.
Okay. Any other questions?
Very good question,
Anybody,
thank you.
anybody else have any other questions? Well, I want to thank you again, because these meetings we have are very informative, and we've kept this under 2 hours, so only an hour and 20
Great.
minutes, so we're great with that. And also, we will continue to do this, because the only way we learn this stuff, and while we have a master, two masters sitting at the end, we will use you as much as possible. And I am going to follow up also about maybe when we come back, because we're going down Friday, the Board of Aldermen, when we come back, maybe having some classes for the members of the Board of Aldermen. And I would suggest that other elected officials that are not mandated might want to do the same thing, because just because you're elected, it does not make you know what you're supposed to do, or the rules, or how to do things. And it would be very good to have refresher courses, even if you do know, because things, as you said, do change.
We had Alderwoman, I'll end with this, when I worked for the judicial system, I had a judge who, I fell out of my chair again, but we had an older lady, she wasn't really that old, but he asked her, well, you know, he was interviewing for court clerk, you know, do you think you've got enough energy left, you know, and I'm like, oh Lord, and saying, you know, are you gonna work that much before retirement? Excuse me, pardon me, and he says, well, I have judicial immunity. I said, not under Title VII, no, that doesn't protect you, so you're right. I mean, I think that you can go up as high as judges and still realize that you're not immune from these issues, so.
Well, I was told that when I ran for office. Jack Garvey and I ran. He was a prosecuting attorney and I was a public defender. And one of the judges told me that, well, you can't run for office because public defenders can never get, and it wasn't harassment or anything, but his idea is that public defenders could never get elected. So the next day, Jack and I came back to work after we won, and I said, well, Judge, I guess they didn't know I couldn't get elected. And then Jack and I, we came over here, we shared an office actually. We always used to joke and laugh about that, because I didn't really get elected, okay? So people have preconceived notions that get changed. And again, I want to thank you, appreciate it, hope you'll come back.
Thank you very much, thank you.
Thank you.
Thanks, Sylvia.
Have a nice day, thank
You
you.
guys do a great job.
Thank you very much.
Bye.
Stand back.
Oh, okay.
Thanks, Teresa.
I had, okay, I just think, and so the Public Employees Committee is adjourned, okay?
Thank you.